Democrats and Democrats have done it again. Today, they have introduced a bill that is 164 pages and strikes out the word mother at least 370 times. They've even removed the term breastfeeding and instead they've called it person breastfeeding and chest feeding. Yeah, because men can breastfeed, right? This isn't the party of science. This is the party of insanity. This is what happens when you're ruled by a radical left woke agenda. You can't even say the word mother. And you have to say pregnant person. You can't say mother. You can't say breastfeeding. You have to say chest feeding or person who breastfeeds. Oh, good. I was crossing my fingers that intro would go good because my daughter just did that for me.
Go daughter. Yeah.
Yeah, it's a little long, but yeah, we're working on it. So welcome to Moms for Liberty Unplugged. I'm Scarlett Johnson, Rosalind Hanson, and we have with us the infamous Sarah Parshall Perry. I am so happy to have you on. I've got about 1 million questions and 50 minutes to get them all in.
Bring them on.
And her Wisconsin nice might not help us get through that so quickly. So I'm here to move it. I'm here to DC move it along.
Oh, yeah, definitely. But first, just to say a few things, Sarah Parshall Perry is the Vice President and Legal Fellow at Defending Education. And before coming to Defending Education, you served as the Senior Legal Fellow for the Edwin Meese Center for Legal and Judicial Studies, part of the Institute for Constitutional Government at Heritage, where you worked on civil rights and the proper role of the courts. And before that, you were senior counsel to the Assistant Secretary for Civil Rights at the U.S. Department of Education. So you are the expert that we need to talk to right now about so many things that are happening in this country that matter to listeners, to Moms for Liberty, and to parental rights activists and sane people all throughout the country. So thank you for coming on.
I am so happy to be with you guys. There is definitely a lot to talk about.
Yes, a lot to talk about. And let's start with there's two big things, and we'll start with the recent Supreme Court decision that upholds the Tennessee ban on gender-affirming care for minors in the United States versus Discrimination. And you are the person that I really have wanted to talk to about this. What is the good news besides the obvious? What is the good news about this decision, and what are the things that are still kind of murky? What are the things that we should celebrate, and what are the things we still have to watch out for?
Yeah, that's a good question. So we can celebrate the fact that they determined that Tennessee's law that was banning so-called gender-affirming care for minors under the age of 19 was in fact constitutional. And it was constitutional because they deemed it was not a restriction based on sex or transgender status, but rather a restriction based only on the age of the individual seeking the treatments and the medical diagnosis that that individual had. Those two types of restrictions are wholly constitutional, and they're well within the state's what are called police powers to regulate the practice of medicine within the state. So this was an outcome very much like the Dobbs versus Jackson Women's Health decision from 3 years ago, which of course actually came down 3 years ago today. So the timing of this is really fortuitous. You see really sort of the same rationale from the court. Alito wrote in that decision that they were going to return the issue of abortion, highly debated, very contentious, subject to scientific discourse and disagreement, back to the people and their elected representatives, and almost taking the exact same line. The Chief Justice, writing the opinion in Discrimination, said almost the exact same thing, saying that it was time to send this contentious, highly debated issue back to the people and their elected representatives. And that is a good outcome for representative democracy. But the unfortunate outcome is that this leaves the door open to other potential challenges. There was, of course, an associated case, LW versus Scrimetti, and this is a case brought by parents who said, we have a constitutional right to seek and achieve gender affirming care for our minor children. But that case is still pending on the Supreme Court's docket. Now, we don't know what the court will do with that precise decision. Will it send it back to the states as well? Will it dismiss it? There's a Supreme Court procedural outcome called the dig order that's dismissed as improvidently granted. And if they dig a case, they eventually send it right back down to the court that it came from. So there are going to be continued challenges to these bans on so-called gender affirming care, because those individuals who want gender affirming care won't stop. This is for them the hill on which they are dying. We've seen it in women's sports. We've seen it in drag time story hours, in public school. This is something that they feel strongly enough about that they will continue to litigate. And in fact, the president of the National Center for Lesbian Rights said specifically, we're going to mount additional challenges because they left a number of questions open, not the least of which was, do parents have a right to achieve this care? So I think we're a long way from finished, but it was a very moderate decision. I am surprised it wasn't 9-0. I'm frustrated it wasn't 9-0. But knowing the hard left liberal wing of the court, I think it's something we kind of all anticipated.
So the question that I have, and maybe I'm asking for the lay lady, like I'm your child in the car seat next to you, right? This case, and correct me if I'm wrong, was based on rational basis, rational scrutiny, right? And there's different levels, rational, intermediate, and strict.
Right.
And so can you help the lay people of the world understand the differences of those? And then I have a follow-up question about due process in the 14th Amendment.
Yeah, that's a great question. So considerations based on biological sex are subject to what's called heightened or intermediate scrutiny, because the court considers individuals based on biological sex to be members of what are called a so-called suspect class. Now, that just means individuals who were born with certain characteristics, whether that's your race, your national origin, your ethnicity, your biological sex, but they've never equated sex with transgender status. And they've never determined that transgender individuals are themselves a suspect class that are subject to intermediate or heightened scrutiny. When you go to First Amendment fundamental rights challenges in the Constitution, those are subject to strict scrutiny. This is what we see, for example, when it's a free speech challenge or a free exercise of religion challenge. At the lowest tier is what's called rational basis. And that just means that a state has advanced a rational interest in doing something important and that they are substantially related to one another. That is a significant outcome that automatically swings the pendulum of power toward the state in whatever it regulates at the state level. And here, because these were simply age and medical diagnosis restrictions, they applied the lowest tier of review, rational basis, saying, listen, they sifted and weighed this issue in the legislature. It was their democratic consideration that these were appropriate. They didn't want minors performing irreversibly damaging procedures or chemicals on themselves. And so they took the lowest approach to restricting and reviewing what had happened in Tennessee, because those laws under rational basis review are presumptively constitutional. Tennessee was guaranteed to win.
So just to make sure I'm following, with rational basis, the court said because this isn't free speech, religious liberty under the First Amendment, the state has a rational interest to regulate this and has done so through their legislative means.
That's exactly it.
Yay! I get an
A+.
Yay!
Well, another big thing that we celebrated yesterday was 53 years of Title IX. And in my opinion, the best way to celebrate Title IX is to protect it and to maintain the integrity of Title IX. So I would say the number one question that I deal with in my state of Wisconsin and with Moms for Liberty nationally, whether blue state, red state, but mainly in the blue states, are what do we do about Title IX? We know President Trump had, like, one of the first things that he did, he signed executive orders defining sex, male, female, biological sex, protecting women and girls sports. And he's been trying to root out DEI and gender ideology out of K through 12 education, out of colleges and universities and medical schools. And in every sphere, he's trying to root it out. And in every sphere, the Trump administration is facing legal challenges and local district courts, everything that's happening right now, fighting against, what we have been fighting for. So what do you say to the parents who are in blue states like Illinois, Maine, California, Colorado, Maryland, that they're just frustrated because they're not seeing the relief that they thought that they would see with everything that Trump has done?
It's funny because the wheels of government really do grind very, very slowly. And this administration's been moving fast on a lot of things, but unfortunately, they are hamstrung by the very nature of American governance, which is bureaucratic. I think the best encouragement I can give those parents who are in the blue states is to watch what the federal government is doing. They are going to use, for example, Maine as a test case. Now, the Department of Justice has already sued the state of Maine because we remember Governor Janet Mills standing up famously in the White House, confronting the president to his face, saying, "I will sue you in court." Well, I just don't know if she thought it would come with a money back guarantee, because she is now indeed in court. Now, they have indicated that they are willing to take these recalcitrant states and districts to federal court to enforce the protections of Title IX. They've just done it in California against the California Interscholastic Athletic Federation. This administration is very, very serious, but I think we can tell parents, look at what's happening in Maine, because so goes Maine, will go the rest of the country. Now, you've already got 26 states who've fallen in line on women's sports bills on specific biological protections. Shock and awe, which is exactly what we knew when the law was passed. It was intended to protect in 1972. For those who are holdouts, it is really important to watch what the federal government is doing with its Department of Justice and Department of Education. The power of federal investigation should be enough to get these specific school districts and these states to back down. And for parents everywhere, I would say the law is on your side, and now you have the power of Washington behind it. I would utilize as many examples of the federal government's investigatory powers as possible so that you can point out to your principal, to your school board, to your state superintendent, watch what is happening at the Department of Justice in the state of Maine, in the state of California. The law is on our side, and soon enough, the federal government will be coming for those recalcitrant districts as well.
Yeah, I mean, even in Illinois, there are areas of Illinois where we have live streamed the school board meetings. Traditionally, these are blue areas where parents are lining up to speak out because now 7th grade championship track and field, there's a biological boy running circles around all of the girls in the bathrooms where the girls were in some cases forced to change there, where teachers and administrators stood by the door and would not let the girls leave. They had to change in front of that boy. They have gone so far that normies are waking up, that people that normally like, hey, it didn't happen to me, or they believed that those of us who've been talking about this for years were exaggerating. Well, now, the woke chickens have come home to roost, and they're roosting in middle schools all over. And parents, regardless, Republican, Democrat, not political at all, they're really upset. And I know my friends like Wake, Illinois, they and their Moms for Liberty in Illinois, they've been fighting really hard, and they're finally getting some traction in the movement because of how far the woke have gone.
Yeah, it's interesting because this is such a strange hill on which to stake the entire claim of woke activism. And I do believe it is one of the silent referendums that we saw in the election back in 2024. And while everyone was focused on the economy, while they were focused on crime and immigration, to a much lesser extent, a little bit on abortion as concerned what was being legislated in the states, no one was talking about gender identity. And yet that is the issue, I believe, turned the tide of the election, not just in the House and Senate, not just in the White House, but through the majority of governors' houses all the way across the country. The minute a suburban mom who's never been involved in politics before has a daughter with her teeth knocked out on a field hockey field, that is one of those things where you finally have to wake up and go, this is truly something now that is in my house that I cannot get away from. And it's important to be able to recognize that not only is science on our side, not only is the law on our side, but biological, immutable, inerrant truth is on our side. In fact, 80% of Americans of all political stripes want men and women's sports separated. They recognize that. Now, why it's not 100, I don't know. We are pushing to continue to turn that tide so that everyone wakes up and fully understands that. But there's going to be a very necessary, I think, reckoning for exactly what's happening at the local and the state level, because the federal government can only do so much and can only investigate so hard and so fast. But it's incumbent upon everyday parents and individuals who are watching this broadcast right now to stand up, to speak the truth, to identify that the emperor is indeed wearing no clothes, and that you have the power of the federal government and federal law on your side.
Yeah, I mean, I can tell you that what you just said is absolutely true, because in the state of Wisconsin, a battleground state, I was a surrogate for Trump and went throughout. We have 70 counties in Wisconsin. I was in most of them, talking to everyday normal people, many of whom were not politically active before the 2024 election. And the number one issue that got the applause, that had people lining up to talk afterward, was boys and girls sports, boys and girls bathroom, gender insanity, what they're seeing in schools, the curriculum, what they're seeing at their even in common council meetings, where like these smaller positions are taken over by woke activists because people were asleep. And so I can tell you for a fact that the state of Wisconsin was won by Trump because groups like Moms for Liberty, Defending Education, we have Wisconsin Institute for Law and Liberty. I know you know them well. They're a 501c3 and involved, but because of everything that we had been exposing, sunlight is the best disinfectant. It really woke people up, and they just said, I've had enough. I can't take any more of this. And the number one applause line that I would get is, let's make America normal again. Let's make America sane again. And that's what people wanted. They just want to return back to normal.
Just on the anniversary of Title IX, I just filed a federal complaint against Smith College with the Office for Civil Rights, because as an all women's college, they have held themselves out to be only for women, something that is constitutional. The Supreme Court has said, as long as it is substantially equivalent to its sort of partner institution. Here, these are called the Seven Sisters institutions. They were traditionally all women's colleges, and they only accepted women, and they were essentially designed to be partners of the Ivy League colleges that were only for men at one point in America's history. But they still hold themselves out to be a women's college. And because of that, and because I know now, after a little bit of investigation on my own, that they admit natal men and to open up their bathrooms to anyone and to open up their locker rooms and their dorm rooms to anyone, I filed a federal complaint with the U.S. Department of Education. That is a power, by the way, that every parent who's listening, who knows about discrimination in their school district or in their state, can actually do. All you have to do is go to the portal for the Office for Civil Rights at the Department of Education. You can find it pretty quick through a Google search, and anyone can fill out the online document and submit a complaint to the Federal Department of Education.
So I want to ask real quick, if we can, I want to go back to one more question about Scrimeti and then maybe look into the tea leaves for Mahmoud. Is that okay? Yeah. So some of the articles and opinions I've read are like, anyone who supports parental rights and individual liberty should be really disappointed in this case because it didn't enshrine parental rights for the parents to decide that their children should get this gender affirming surgery. And so they were saying that they were disappointed in the due process and 14th Amendment. So can you speak to that about like why that really wasn't an issue in Scrimeti?
Yeah, that's a great question. That's because there was that partner case, LW versus Scrimeti, that is still in a holding pattern at the Supreme Court on a petition for cert. Now, the case that we heard was United States versus Scrimeti, and that's because specifically under federal statutory law, the United States can intervene through the Department of Justice if there's a question related to equal protection. That was the question at issue here. It is considered an issue about which the federal government has a specific stake, but they didn't address the parental rights issue. That is in the partner case of LW versus Scrimeti. Now, what will the Supreme Court do with that? We don't really know, but I've written extensively on the fact that yes, there is a parental right to direct the care and upbringing and the education of your children. And that does generally include a medical right to direct their care. But never has the Supreme Court, or for that matter, any federal appellate court, determined that that highly controversial or experimental treatment is something to which parents have a constitutional right. In fact, the most recent court to weigh in was the DC Circuit Court of Appeals, which is often called the nation's mini Supreme Court because so many cases from the DC Circuit go up to the Supreme Court because the United States is quite often a party. That was actually back in the year 2000 with Justice Ruth Bader Ginsburg, in which she specifically said in a case where an individual whose daughter was on life support wanted to get her an experimental treatment, she determined in writing for the majority that there was no constitutional right of that parent to seek experimental care. My great guess is if this question comes to the Supreme Court, or if they take LW versus Scrimeti, and if they want to address the parental right aspect, they will determine there's no longstanding liberty interest in getting experimental treatment for a minor child. And we've seen this in the states. In fact, some states have passed abortion notification laws that restrict parents' knowledge from when minors are getting abortions. This is going to be a question that the Supreme Court will have to wrestle with. But I know, Rosalind, you were talking specifically about Mahmoud. That is a parental rights case. Now, here's where I think that is going to go. And based on the oral arguments, I used to have a boss who would say, don't predict, it's dangerous to predict, except every time I predict, I'm right. So I'm going to predict yet again.
What are the lottery numbers for today?
We're getting opinions Thursday, so it might come out Thursday. I think we are going to see a 6-3, if not a 7-2 decision, to the point where I think Justice Kagan on this will be the swing, because during oral arguments, remember, this is this pro-LGBTQIA plus curriculum through public education in Montgomery County, which, by the way, is a typical bad actor. They also hide gender identity information from minor children.
I know.
So you know it so well. In fact, there was a case that went up on a cert petition that the court didn't take, John and Jane Parents 1 and 2 versus Montgomery County Public Schools, about a challenge to gender confidentiality policies because they were an interference with parental rights. This one, however, the court did take up based on oral arguments. I feel very good that the outcome is going to be for the parents, but here's why they really don't have to wrestle with that tricky parental rights analysis. All they have to do is apply a case called Wisconsin versus Yoder in 1972. And in that case, it was determined to be a violation of the religious liberty of parents to direct their children's religious care. So they don't even have to go into the non-religious question like they would have to do with a medical case on gender affirming care. They can simply say, we're just going to look at this from a free exercise religious liberty perspective. and it's a pretty cut and dry analysis. So that still leaves the door open to parental rights challenges on the specific aspect of whether you have a constitutional right to get gender affirming care for your minor child. So I think the Scrimetti decision, and you had asked about sort of the things that we still need to look out for, Scarlett, this is one of them. Those parental rights challenges are still in the offing, and we have nothing in terms of direction from the Supreme Court yet.
Yeah, the case is very important to Rosalind, as I'll let you talk about it because.
Well, I am one of the unnamed plaintiffs under the Kids First Unincorporated Association. So I am losing a lot of sleep and sending up a lot of prayers right now, as with most of America, because the great thing about this is that it will have national impact.
Yeah.
And so what do we do in the aftermath, God willing, that it does go the way of parents? And maybe not for today, but I did take a little bit of time and created a Mahmoud B. Taylor bingo board for you, Sarah. So maybe when
I love it. I love it.
Actually come out.
We have 6-3 ruling in favor of parents right at the top.
You already mentioned Wisconsin v. Yoder. Okay, right?
Yep, that's exactly it. All of that stuff. Ooh, this is great. This is very, very good.
So maybe as we lead up to it, we can offer it as a template and people can rearrange their squares and we can have winners and losers, whoever gets bingo first, right?
I love it. I love it. And listen, we heard Kagan herself say, well, I think even non-religious plaintiffs, non-religious parents are going to have a problem with the appropriateness or lack thereof of this material once you're talking about kids that are this little. Remember, as you know so well, 4, 5, and 6-year-olds. Identify the, leather-clad S&M activist. Identify the trans flag. You're at a Pride event. And this wasn't just for Pride Month. This was an incorporation of this type of curriculum all throughout the entire school year in the English language program. So there was no right of opt-out. So they have a right of opt-out when you're going to sex ed, which is ridiculous, but they don't give you a right of opt-out if your child who's 4 years old in pre-K is looking for a drag queen. That to me is unconscionable. And I'm hoping that this is an opinion, and I think Chief Justice Roberts is going to assign it to Alito. As the chief, he gets, when he's in the majority, the right to be able to sign who the author is of the opinion. I'm guessing he's going to give it to Alito. So if that doesn't appear in your bingo card, it should.
It does. We need to add that in. Yeah, like what else do we need to add to the bingo board? Alito's going to write it. Okay.
That's it. That is exactly it. That's who I think is going to write it. And I think we're going to get Kagan. So, it could be, in the end, it could be a 7-2, which would be really a victory.
I can tell you firsthand that I just got an email right before the end of school year in May, in which, you're getting closer to June, where a 6-year-old it was from parents of a 6-year-old. The school spent the week talking about gender identity, and they watched videos with books, what are your words, books about transgender, books with pronouns. And at the end, the kids sat around in a circle and they got to play with their pronouns. And each kid had to come up with a new name, a new identity, and a new pronoun. And when the kids contacted the principal and superintendent, they were told, we will not give you a heads up when we talk about these things. They're incorporated just as in Mahmoud, they're incorporated in English. They're incorporated in different aspects of the day in education. So it's not part of sex ed education, which is guided by statute in Wisconsin, as it is in most states. We have 2 pages of statutory guidelines, and parents do have the right to opt out. And that's why I think very deceptively, gender ideology is often interwoven into other subjects so that parents don't have the right to opt out, because they can't opt out of English class or social studies or math. Yeah. And so that's where we see this kind of language and the books during library time and circle time. And so would the decision, if it goes as well as you think it is, what effect will that have on Purple State, Wisconsin, or other states?
Yeah, that's a great question. You know, these curricular opt-out rights are established, as you pointed out, in state law at the state level, right? So there's no national right of opting out of material. This is specifically one of those police powers I was talking about that the Constitution under the 10th Amendment gives back to the states, right? Unless it's expressly reserved for Congress as it lays out, then it goes immediately to the states. Education is one of those issues. That's why you hear conservatives calling for the dismantling of the Department of Education, because it never should have been created in the first place. Nevertheless, we see these particular opt outs. What it will do is provide religious parents with a right of opt out. My bigger concern is that parents who don't necessarily have a religious objection to material like this in the classroom, but might, for example, just morally oppose it, developmentally oppose it, philosophically oppose it, may not have the same strength of right. And that gives me pause. I'm hoping that the Supreme Court's decision is not quite as narrowly cabined as I think it's going to be, with Alito just applying Wisconsin versus Yoder right down the sticks and only addressing the religious liberty element. I'm hoping that they take a more fulsome approach and they address curricular opt-out rights, not just for religious parents, but for non-religious parents as well.
I want to pause here for a second and maybe look at some of these comments. And then after that, maybe we segue to like how Moms for Liberty and Defending Ed have partnered together in the work that you guys are doing in the future. But a lot of these comments are talking about it should be an opt-in or not an opt-out, or these are comments that they don't know what the opt-out is. And so there's a lot of grassroots work on educating families about what's going on at the most local level at schools, because these opt-outs are very common and very easily implemented across every school district. Am I wrong? Am I right about that? What do you two think?
No, you're 100% right. I do want to encourage everybody who's watching. First of all, love the idea of an opt-in as opposed to an opt-out. For anyone who's got connections with local legislators. In fact, it doesn't even require a personal relationship. You start calling your state legislator. You have a right of access. They are essentially working for you. If you've elected them, they are, as somebody who represents your constituency, duty bound to have a conversation with you about this. Maybe there's an opportunity to legislate in some of these states. Maybe those opportunities will increase after the Mahmoud decision. But also, I want to encourage everybody who is watching this right now that you have a federal statutory right to examine the curriculum that is going to be taught in your child's classroom, every little bit of it, regardless of whatever teachers and administrators tell you. You can say that you've gotten legal advice. I'm not the lawyer for anybody who is on this call right now. I have to offer that disclaimer. I'm not curing malpractice insurance, but I am as an attorney who has worked in the federal government, telling you, you have a right of opt-out. Federal statutory law actually gives you that right. So make sure you don't just examine the sex ed curriculum. Take a look at all of it. And sometimes it can take a long time. And sometimes they say, okay, you can look at it, but you have to sit here in the school office and do it. Do what you can to take a look at what's going on in your child's classroom.
Yeah, and you see this question right here. I signed the opt-out form at the beginning of second semester. I requested the health ed curriculum. The school didn't respect my parental rights to opt out. If I would ask, what state are you in? But Defending Education offers a portal in which parents can, find their state and issue complaints. And then sunlight is often the best disinfectant. At Moms for Liberty, we do the same thing. We have portals for complaints. You can look at our map, find your local chapter, and talk to your local chapter chair or statewide ambassador. Email Moms for Liberty and go to momsforliberty.org. But there's all sorts of ways that you can bring attention to these issues. Lots of times it's hard to get a case all the way to the Supreme Court. It's hard just to even get a case together. And when that happens, it takes a very long time to litigate it. And so while, there's like, for example, Wisconsin Institute for Law and Liberty, Alliance Defending Freedom, a lot of different groups can issue letters, cease and desist, all of that, and that can be helpful. But oftentimes just exposing what's happening, making your community aware, going to school board meetings, contacting your superintendent and your school board members and letting them know that this is happening, that you've requested something that you are legally bound to receive. You have the right to review curriculum. They cannot withhold that from you. And there could be a pro bono attorney that could simply write a letter for you, and that might move the needle.
Yeah, that is absolutely great advice. We have something called the indoctrination map at defendinged.org, and it is literally pointing out where the school districts are in the country that are not only engaging in sex discrimination and pushing gender ideology and hiding gender identity information from parents, but also where you're seeing things like DEI, critical race theory, kids being told that their implicit white bias makes them racist, kids being told that George Washington was a racist. We have tracked all the way across the country. And so many of these times, as you guys know, you follow the money and you can find the root of the evil. Consultants all across the country are being paid to provide gender identity curriculum or equity-based curriculum. Equity, of course, being unconstitutional. It levels the outcomes, gives everybody an equal outcome, even though that's discriminatory because it requires one person getting less than another. And in fact, under the 14th Amendment to the Constitution, the promise is equality. We all start on level footing, but we just tracked 11 states alone. There were $9 million tied up in equity consultants so that the grades of states like Georgia and Oregon and Virginia could dumb down their actual grades. That for me is something where I go, where is the money being spent? Because wherever you're spending your money is exactly where your priorities are.
How many millions, billions of dollars in ESSER funds were funneled to schools, and that money turns out was spent on DEI and waste, just a lot of wasteful spending where we saw our kids in America, they can't read. They can't read at grade level for the most part. And it's shocking. It's appalling that the mismanagement of funds, and yet all that we ever hear is more money, more money, more money. Show me the money. That's all Randy Weingarten can ever say. More money and we'll fix the problem. And it never happens. It just keeps getting worse because these funds aren't going into classrooms. They're not going to teachers. They're not going to reading specialists or math specialists. They're going to fund, the apparatus.
Well, and I'll even share in Montgomery County here, right? We've spent millions of dollars fighting this case all the way to the Supreme Court, millions of dollars in taxpayer funding. And yet we still just approved a $3.6 billion with a B budget. We had to pull $50 million out of our retirement fund from our government county council. So retirees healthcare, $50 million as a one-time to further fund. So it's like, it's never really about the taxpayer money, right? And getting it to the most local need, right? The kids who can't read on grade level. It's about fighting for the agenda and for what they're trying to prove and push and prioritize. We'll even take money from the retirees at this point to keep pushing this up.
Building funds, that's a big one. If anyone listening who has kids in public schools, you know that there has been a referendum. There's a referendum every 5 years. Building fund, operational budget. It's never enough. They say, oh, we're going to $58 million will fix it. And 2 years later, oh, we need another $36 million for operational. They refuse to shut down buildings, even though the enrollment's declining. They can't ever cut down the administrative staff, which is growing tenfold. There's for every administrator, it used to be on average thered be 10 to 15 administrators. Now it's 30 to 40 administrators and growing.
Listen, we spent $3 trillion since 1980 with the Department of Education, and we have nothing to show for it. Our National Association of Education Placement rankings are abysmal. We are 27% literacy in math and 30% literacy in English at the 8th grade level across the country. I mean, we actually see states like Georgia who went 3 years without giving a single student a letter grade. In Virginia, we literally start at 50%. And that is where everybody is. Even if you cheat, fail a test, or don't show up for the test at all. These are unconscionable policies that are producing kids who are not ready for the real world. But once again, all you have to do is identify where this money is coming from. Like I said, we only looked at 11 states, just 11 states. Immediately within the span of about a week, we identified $9 million in equity grading consultants. That's unconscionable.
Wow.
So, Sarah, let us ask you, maybe you want to share with everyone who's listening, what is on the horizon at Defending Ed? Are there any updates or projects you want to talk about?
Yeah, we actually are very excited about this because I was looking forward to an opportunity to punch Governor Polis right in the mouth in Colorado. But the institution of HB 251312, which is their misgendering law, we actually are suing the state of Colorado. We are in federal litigation right now. I am thrilled to announce, in addition to 2 other parents' organizations, and in addition to Do No Harm, which, as you guys all know, is fighting gender identity in medicine, because the definition of gender identity and misgendering applies in the state of Colorado to any location that is deemed a public accommodation. And they define public accommodation so broadly that it is any business with an open door to the public. It could be a mom and pop bakery of 2 people. That is considered a public accommodation, which means if a customer comes in and says, I want a gender identity cake for my gender transition, you are duty bound to refer to that individual by their chosen name and chosen pronouns and to bake that cake, because Colorado can't seem to get the message. It's gotten to the Supreme Court twice, once in the Masterpiece Cake Shop case, right? Once in the 303 Creative Christian Website Designer case. But once again, it's back to the drawing board and discriminating. And in fact, this is an amendment to the Colorado Anti-Discrimination Act, or CADA, which was at issue in Masterpiece Cake Shop and in 303 Creative. But no matter for Colorado, they are so bought in to gender identity that they are going to continue to push forward no matter what.
Yeah, we just had a town hall in Colorado. Tina Deskovich, CEO of Moms for Liberty, was there, and we had our chapters with Moms for Liberty in Colorado working with Erin for Parental Rights, Jennifer Say, a whole host of parental rights organizations in Colorado. And that I was just glued to watching that 2 hours, the stories that I just when I think I can't be shocked by what's happening, I was blown away at what was happening in Colorado. That 13-year-old girl, autistic, was so indoctrinated that she eventually ran away from her loving and caring mother to go live with her math teacher. And that was okay. That was the Colorado, they did nothing about it. And when I tell this to Wisconsin, like, hey, if we don't turn things around, we're going to look like that too. Don't think that we're different. You know, we're going to adopt all the same policies, but we're not going to end up in this insane place. It seems like it just gets more insane in a place like Colorado and in California. And I'm so glad that you are doing this, because the parents there that are fighting they're just warriors. And Jennifer Say, I know, I love her. She's great.
I like Jennifer Say's new take on no HR. The word police. Yeah.
Well, I can also tell you that Alliance Defending Freedom brought suit on behalf of a couple of their plaintiffs, including Jennifer Say, right after we filed. So I got to tell you, there are at least 2 federal lawsuits that I know of. I'm hoping that there are more. It's going to take federal litigation, unfortunately, in a lot of these contacts with gender identity to reestablish the rule of law, to protect free speech and the First Amendment, to protect biological reality and minor children. And let me also encourage people who are listening to take a look at your state's child welfare code. Take a look at what they define abuse as. Does your state actually define abuse to be misgendering or dead naming a child? We have seen those types of state laws attempt to be passed, and in some states passed, which are immediately a red flag for parents there to recognize that the state can and will deprive you of custody of your child on the basis of gender identity. We know already that a number of these state family courts, and these are very sort of, they're mini fiefdoms, right? So these are not federally appointed judges that have to go through a confirmation process. These are state politicians, essentially, who are now acting as judges and who are making horrible determinations about what parent is going to get custody of a minor child based on their support of that minor child's gender identity. I've known too many horror stories about this. This is not sort of in the ether. This is happening in state law. It's happening in family courts across the country. So take a look at your state laws, see how they define abuse, because you will want to be on notice if something like this comes home to roost.
You were with us not too long ago in DC when we celebrated Pierce versus Society of Sisters. It celebrated 100 years of the Supreme Court defining and protecting parental rights. And so what do you have to say in our final minutes? What do you have to say to parents, the parents, Moms for Liberty, and that are just, this is our number one issue. This is what we're fighting for. Hard to believe that 100 years later, Oregon's still woke.
Well, that's exactly it. And in fact, it's interesting to me that the first case that was any iteration from the Supreme Court on the notion of fundamental parental rights was actually Meyer versus Nebraska, 1923. So 2 years before Pierce. So the Supreme Court has had a lot to say on this. And it is my hope that we get some clarity in the Mamu decision, that we get a broader decision than just a decision based on the religious liberty of the parents, that there is some kind of a statement from the Supreme Court, a determination of the Supreme Court on exactly what that looks like. And part of the problem, and you guys know this, is that this fundamental parental right, as far as the Supreme Court is concerned, roots itself in the 14th Amendment to the Constitution, which is a tricky part of the analysis because a lot of conservative legal scholars and jurists do not like the 14th Amendment for the purpose of creating what are called unenumerated rights. So it's always been a tricky analysis for us, but we understand as moms that the parental right is pre-political, it is prejudicial, it is from time immemorial, from the dawn of human civilization. It is something that we need to work zealously to protect. And it is not going to get easier. It's going to get harder because as sort of the transgender juggernaut continues to face blockades from the federal government, they will send a lot of this underground, which is why it's so important for parents to perform the necessary investigation, to look at the curriculum, to look at your state law's definition of abuse, to talk to your state legislator, to see what's moving in your state house or your state assembly, because these are not days for lazy parenting. These are not days for resting on our laurels. We have someone who is definitely with us. The wind is at our back. The Supreme Court will probably give us a good decision, but in the end, we really have a long way to go.
It's still up to parents, right?
That's exactly it.
Yes, I think the number one message is, yes, it was a tremendous victory for sanity in November, and started out January like great, all of these executive orders. And I think a lot of people thought, oh, okay, did my job, it's all taken care of. I can rest now. No, because these woke revolutionaries, what they don't rest. They, as we can see, they will keep going, and they will work through the legal system, and they have captured education. This is This is a marathon, not a sprint.
Yeah.
Took them a long time to seize just every educational institution in the country. And it will take time for us to work the woke out of these institutions. So we have to be in it for the long haul.
Yeah. And in fact, this is, education is target number one for these revolutionaries, right? I mean, this is cultural Marxism. We've heard the term before, but this is really what it is. It's Saul Alinsky's rules for radicals, right? You isolate individuals, you keep them sort of derided and discouraged, you depersonalize them, make them inhuman, and then ultimately you cut them out altogether. And if you can get American public education, you can secure an entire generation to a left-wing progressive ideology, because then they go into higher education, which is already bought in to liberal academia. It is already 96% liberal. Only 4% of higher education professors or teachers identify as being conservative. So many of the conservatives are underground. So it's already taken by liberal interests in academia. And then they go forward to vote those values, to parent those values, to seek gender affirming care, to push for pro-gender identity curriculum in public education. So you realize if you can capture the young, fertile, moldable minds of our children from pre-K on through high school, while they are still under our roof and subject to our authority, our parenting, and our governance, you've locked them in for the rest of their lives. And that's why I think so many of us moms feel so passionately about public education, because not only do we want it to work for everyone. I was a product of public education. My oldest was a product of public education. I grew up in Wisconsin. There was North Waukesha South and Waukesha North.
Yes.
And that was it.
I know Waukesha is under, oh my gosh, Waukesha once a deep red is,
yes.
Oh gosh.
Very, very deep purple to trending indigo. And in fact, State Representative Barb Dietrich, who is a good friend of mine, who represents the Waukesha district, has been working incredibly hard to protect things like women's sports and fiscal sanity. But this is ultimately for us. It's only going to be won by us. We are the people, the individuals closest to our children, but their education and their values and their upbringing. It's not a time to rest on our laurels, unfortunately.
It's time to run for school board, because still, and I know you would agree, we can talk about everything going on at the federal level, but what really matters, because education is still, and that's where we want it to be. We want education to be local. We don't want to federalize education. School boards are still where the power is at. There's so much more power in the school boards than I think most people even realize. They set the curriculum. They can fire superintendents within reason. The attorneys that give them the advice, they have the opportunity to get new attorneys if there's one that is woke and not telling them the whole legal story, which often happens. So the power is still local. That's what we really want to emphasize, that while we love working with the Trump administration, and while we see the value in that, you have to still care locally. You still have to go to your school board meetings and participate in, the local politics of your area, because if you don't do it, someone else is going to do it for you.
Now more than ever, we have to stay engaged. With the last 2 minutes, Sarah, we know you have to hop off and keep on fighting for liberty. Any last words?
I would say just be encouraged. We've got 3.5 years to do a lot of heavy lifting, but the tide is turning, and it's going to be incumbent upon us to take this opportunity to really seize it and to make a difference. Scarlett, I love what you said about running for school board. I do believe those are the most important political elections that we see anywhere in the country. I used to live just south of York, Pennsylvania. I had a good friend who was in advertising, who decided that the curriculum was so bad for his children that he and 5 other individuals, none of whom had ever run for political office before, all turned the school board red in York, Pennsylvania. And they are now protecting women's sports. They are protecting religious liberty. They are balancing the budget. This is how it's done. Again, this is not an era for us to rest on our laurels, but be encouraged, because for the first time, we've got a good Supreme Court. We've got a good president. We are getting good outcomes. We're getting good investigations, but it's time for us to do the heavy lifting too.
Yes. And if you, even if you're in a blue state, if you've got a conservative school board, they don't have to, is this correct to say that they can look to the federal law, and they don't have to fear, they don't have to listen to people say, oh, you're going to get sued or you'll lose federal funding. So they've got cover. They've got cover to do the right thing. So you may have a blue state, but you can run and win your school board and then give cover to your area and protect the children in your area.
That's it. The law is on our side. We have federal law backing us up, giving us the right to examine curriculum, make sure girls' sports are separated, make sure bathrooms are separate. All of these are protections that we already have. We just need to utilize them.
Yes. Well, thank you, Sarah, so much. And I hope that maybe next week we could talk with you again after we hear the decision. I know
I would love to. I would love to. Hopefully we'll have good news by then.
yes, we hope good news. But yeah, and Rosalind, you're taking your son, right?
Theoretically, yes, but let's not totally boil our tea leaves yet, and we will wait for that opinion to come out. But thank you again, Sarah.
Let's hope that it comes out Thursday. Let's hope it comes out the way, and let's hope one last. Let's hope with the. I'm gonna bring the bingo card. Let's hope we have to.
You know what? As somebody who studies about the court, writes about the court, I probably have an unfair advantage because I will probably win bingo on this. So I will eschew my opportunity to play.
Fair enough. But we're going to try and make hard things and hard and heavy topics into something light and enjoyable at the same time, because that's what we do. We're warriors. So.
I love it.
Thank you, Sarah, so much. Thank you. And thank you for all that you do. And thank you, Defending Education. It's a great organization that I know I go to your website just about every day to check the indoctrination map or to put, I've got another school district to add to that map. So thank you.
I love it. Thanks, you guys.
Thanks. Bye. Well, that was a wonderful hour. It was great spending time with Sarah Parshall Perry and my friend Rosalind Hanson. And I think we learned a little something, and definitely we'll be back next week if the Supreme Court decision is released. And hopefully not only is there the decision that Sarah predicted, but maybe even going a step further in defending parental rights. We can only hope for that. Stay tuned tonight. Later on this afternoon, I'm going to be talking with Peachy Keenan, the author of Domestic Extremists, a hilarious book, good book. I love her. She's so funny and smart, and she has a great Substack. She's often on Fox News, and she lectures. So she's in California, 5 kids, and she has 5 kids. She's a Catholic conservative woman who had a brilliant professional career, and she decided, like when she had her children, that she wanted to be a stay-at-home mom and never looked back. So tonight we will air that interview, which I will be doing this afternoon. I'm excited for that. A few things that I need to always point out at the end. Follow Moms for Liberty on X, Moms for Liberty, Moms4 Liberty. Make sure you follow Sarah Parshall Perry. She is Vice President of Defending Ed. You'll want to follow her. I can't tell you how many times, and I'll bring it back on the stage, how many times when I am going to testify in the Capitol, the state legislature, when I'm writing speeches, when I'm going to talk at a school board meeting, that I quote Sarah Parshall Perry. And during the summer of Title IX last year, when former President Biden and the administration attempted to infuse gender identity into the definition of sex, and as far as Title IX goes, for protections against for discrimination. That was a huge summer last year, and she and all of her work and her speeches and the things that she puts out on her social media were something that I used on a daily basis. So follow her. Go to Defending Ed. I know I support Defending Ed. I've attended many of their conferences. I love the organization. They put out, they are now, doing even more because they've expanded into the critical area of higher education. And if you've got college students like I do, you can do everything you can from K to 12, and then your kids go to college, and then what? So Defending Ed is now fighting for our children beyond K through 12 and into colleges and universities. And that's really important, because this is our future. This is our next generation. And a whole lot of our tax dollars go to subsidize and fund K through 12 and colleges and universities. So our state taxes and our federal taxes. So these are important areas, and we shouldn't be paying to turn our kids into communists. I'm just saying. So, and also make sure that if you want to start or join Moms for Liberty, go to momsforliberty.org. You can go there to join as a member, to start a chapter, to learn more. And also we have M4LU, and M4LU.org is where we have just a ton of information on Title IX, on gender ideology, on Common Core, on everything, on every, like there. And then what's coming up with M4LU, we have some more in the fall. There's going to be a plethora of new topics discussed. It's great. And we even have a conversation coming up this week with M4LU. So go there to find out more about all of everything you want to know about education, and the toolboxes, lectures, everything. So please go there. So thank you again for joining. I'm Scarlett Johnson. Thank you, Sarah Parshall Perry, for joining me, and tune in tonight. And tomorrow, one more thing. Tomorrow, Wednesday morning, Tina Deskovich, the Fire of Liberty show. Tune into that. That will be live streamed on all of our social media, and it's on YouTube. It's on Apple, Spotify. Tune into that, where you can listen to Tina as she talks with everyday moms on the front lines. They are accidental activists. They're just like you, and now they have become warrior leaders in their communities. So have a great day, enjoy it, and spend time with your family. Bye.